Bismillahirrahmanirrahim. Assalamu alaikum. Today's video is about burden and standard of proof in a criminal proceedings. So this is also about the law topics. In this video I discuss 2 to 3 topics with you, and let's start. Facts in issue. These are the issues that the prosecutions are required to prove or disprove in order to prove the guilt of the accused, and the issues that defense are required to prove in order to prove a defense that they have raised. The defense do not raise as a fact an issue where a defense merely amounts to a denial of the prosecution case, and the subject to exceptions consider below the legal burden for providing and disproviding all facts in issues in a criminal proceeding in a borne by the prosecution's Woolmington principle. Thus, the general rule is that the prosecutions must prove the element of the offense, actress and means read, and must disprove the fact in issues raised by the accused defendants. And the standard of proof which the prosecutions must reach in order to discharge the legal burden is the criminal standard of proof, namely proof beyond reasonable doubt. In practice, juries are often directed that they must be satisfied. See, you feel sure. This direction does convey the appropriate standard of proof. This so absolutely certainly is not required. The jury should not convince if there is more than a remote or fanciful possibilities that the accused is not guilty, and judges must avoid misdirections that convey too low a standard, such as satisfied or reasonable sure. Examples: murder and provocations. Where the accused is charged with a murder and the defense of a provocation is an issue, prosecutions must prove elements of a murder beyond reasonable doubt, and prosecution must disprove defense of provocations beyond reasonable doubt. Where legal burden of proving defense borne by accused, instantly the only common law defense which imposes a legal burden of proof on the accused are express statutory exceptions. For example, where a state expressly imposes the legal burden of providing and defense on the accused, for example, diminished responsibility under S2 HA 1957, are implied statutory exceptions, where a statute implicitly imposes the legal burden of pronouncing a defense on the accused, governed magistrate by S101 and 1980, are crown court by equivalent common law principles. For example, selling liquor without a license. Essentially, implied statutory exceptions will exist where a state profits a type of conduct but permits it in a specified circumstances, or by a specified class of a person, or by a person with specified qualifications, or by a person granted a license are permission by specified body, but in determining whether a state imposes a legal burden of a proof on accused by applications, the post-court must construction the prevent to determine the intention of Parliament should not to be ready to construct a state having this effect factors such as the difficulties of defense in proving our prosecution disproving the issues may be relevant. So, in Article 6.2 of the European Human Rights Convention on Human Rights provide that everyone charged with a criminal offense shall be presumed innocent until proven guilt according to a law. The imposition of a legal burden of proof upon the accused does not necessarily give rise to a violation of Article 6.2. The question is essentially whether the requirement falls within a reasonable limit which take into account the importance of what is at stake and maintain the accused rights. Derogations from Article 6.2 does not violate Article 6.2 if it is justified and is a reasonable proportionate to Parliament legitimate aims. For example, is there a reasonable balance between the public interest and the accused interest? There must be a compelling reason for imposing a legal burden of proof on the accused, and the greater the penalty, the more compelling it must be. Human rights continue. In determining whether imposing a legal burden of proof on the accused would violate Article 6.2, relevant factors appear to include whether the requirements related to an essential elements of offence, the purpose, whether the offence is a merely regulatory, how difficulty it is like to be for D to satisfy the legal burden, the difficulty for the prosecutions, or if D was not required to satisfy the legal burden, what D has at a stake, the presumption of innocence, Parliament's view as to what is in the public interest, whether the requirements infringes the principle of proportionality by interfering more than is necessary with the presumptions of innocence. If imposing a legal burden of proof upon the accused expressly or by implication would violate Article 6, the court may be required to read the relevant statutory provision down under Section 3.1 of H.R. 1998 as a merely imposing an eventually burden thereupon. Standard of proof where accused bears legal burden. Where the accused bears the legal burden of proving a fact and issues, the standard of proof is a proof on a balance of probability. For example, more probable than not. Example: express stationary acceptations, murder, and dismissed responsibilities. Prosecution must prove elements of murder beyond reasonable doubt. Defense must provide diminished responsibilities where the accused relies upon this defense on the balance of probabilities. Fred is charged with the murder and relies upon the defense of a diminished responsibilities, which is true. The prosecutions must disprove the defense beyond reasonable doubt. Number 2, the prosecution must prove the accused resource of the offense beyond reasonable doubt. The prosecution must prove the main res of the offense beyond the reasonable doubt. And the number 4, the defendant must prove the defense on the balance of probabilities. Threat is a charge with a murder and rely upon the defense of diminished responsibility, which is our true answer. 2, 3 and 4 are true. For example, implied stationary acceptation, selling liquor without a license. Prosecutions must prove sale of liquor by accused beyond reasonable doubt. Defense must prove that accused proceed as a license, where the accused rely upon this defense on the balance of probabilities. Rajeev is charged with filling trees without a license, where one was required by S9 of the Forestry Act 1967. Neither party adduced evidence to prove or disprove that Rajeev proceed a license at the relevant time. Which one is true? Number A is the prosecution must make the tribunal affect reasonable satisfy that Rajeev did not possess a license, and number B is the defense must prove beyond reasonable doubt that Rajeev proceed a license. So Rajeev is charged with the filling trees without a license, where one was required by S9 of the Forestry Act 1967. Neither party adduced the evidence to prove or disprove Rajeev proceed a license at the relevant time. Which one is true? And the answer is both are false. So, evidential burden, no case to answer. Is there a case to answer? Prosecution evidence must raise a prime facie case of the accused guilt. Galbraith test. For example, no case to answer if no evidence on a fact in a issues are if probably directed jury could not convict on the evidence. Ayesha is charged with the thief of the diamond necklace. The prosecution failed to adduce evidence to prove that the necklace belonged to someone other than Ayesha. Which one is true? So number A is the defendants have a case to answer, and number B is there is no case to answer, and number B is true. So evidential burden in relation to defense which does not go from a Woolmington exceptions, where defense does not form an exception to the Woolmington principles. For example, provocation, duress, self-defense, then there must be evidence before the court, not necessarily adduced by the accused, sufficient to raise the defendants. This will appear the case if viewed as the highest. The evidence will be capable of putting a reasonable doubt in the jury mind. So in which case the prosecution bears the legal burden of disproving the defendants. The judge must leave the defendants to the jury even if the accused does not wish to rely upon it. For example, murder and provocations. So, prosecution must prove elements of murder beyond reasonable doubt. Prosecution must disprove provocations if there is evidence of provocation before the court to raise the defense regardless of which party adduced the evidence beyond a reasonable doubt. So Fred is charged with a murder and rely upon the defense of a self-defense. A defense witness testifies that Fred acted in a self-defense. Prosecution witness testifies that Fred was a provoked, which is true. So number 1, the prosecution must disprove the defendants of a self-defense beyond a reasonable doubt. And number 2 is the prosecution must disprove the defense of a provocation beyond a reasonable doubt. And number 3 is the accused must prove the defense of a self-defense on the balance of probabilities. So number 1, number 2 is a true answer. And evidential burden in a relation to defendants which does not raise new issues, where a defendant's, for example, reasonable belief in a constant with a rape does not raise a new issue, then the accused does not even appear an evidential burden because the defendants must merely amount to a tenor of an issues raised by the prosecution. For example, in the case of a reasonable belief in a constant, the accused is merely denied that the processes that required mean real. As was seen above, the prosecution will of course need to establish a case to answer in relation to the issues that they have raised. So Saul is charged with the rape. He pleaded not guilty, but he defends is merely to offer no evidence and to put the prosecution to prove. So which one is true? The issue of a reasonable belief in a constant should not be left to the jury. And number B is the prosecution must disprove reasonable belief in a constant beyond the reasonable doubt. So which one is true? So the answer is number B. So the accused bears the evidential burden and the legal burden in relation to defense. Such a diminished responsibilities are proving that he has a license to sell liquor and may decided not to rely upon the defense. If the accused does not rely upon the defense, it should not be left to the jury, even if there is evidence before the court capable of raising it. If accused raise instant or diminished responsibilities, prosecutions are entirely to raise and prove the other defendants. Criminal Procedure Instant Act 1964. So, admissibilities of evidence, where the admissibilities of evidence depends upon the resolution of a question of fact, that the burden of proving the fact is borne by the party tendering the evidence. The standard of proof, unless statute provides otherwise. For example, in relation to competence of a witness is proof beyond a reasonable doubt, where the burden is borne by the prosecution and is proof on the balance of probabilities, where the burden is borne by the accused. And under section 116 CJJE 2003, the prosecution wished to rely on X harass statement and the defense wished to rely on Y's harass statement. The prosecution arrests that X does not testify to fear The defense arrests that Y does not testify because he is outside the UK and it is not reasonable participable to secure Y's attendance. So which is true? Number 1, and the prosecution must be proved beyond a reasonable doubt that X does not testify through fear. And number 2 is the defense must prove on the balance of a probability that Y is outside the UK extra. And so which answer is true? And the answers are both are true. Okay, so we discuss any other slides now. So the legal burden. The legal burden of a prosecution have your burden and obligation that remain on a single party throughout the claim. Once the burden has been entirely discharged to the satisfaction of the traders of fact, the party crying the burden will succeed in its claim. And Section 101A, he who illegal must prove prescribed burden criminal cases beyond the reasonable doubt, prove to high degree of probabilities but not prove beyond a shadow of doubt. And the other is a civil case, balance of a probabilities that an allegation is a more probable than not. And Tenaga, Nasional, Berhad, Perwaja, Steel Settlement, Berhad, 1995, 4 MLJ 673. The plaintiff must prove such fact as a plaintiff's desire the court to give a judgment as to right to claim against the defendant or the defendant liabilities to pay the plaintiff. The burden is on the plaintiff is in order to succeed here. A plaintiff must prove its claim affirmatively, and the wrong saying charged with the cheating and magistrate help. So, I am satisfied beyond a reasonable doubt that accused failed to establish a case which at least will raise doubt as to his guilt and entitle him to an actual contentions. It was wrong to say the burden of proof had shifted to the appellant. Legal burden never shifts to accused. The onus of proving everything essential to the establishment of the charge against the accused lies upon the prosecution, who must prove the charge substantially as a lead. The on never change to accused to give an explanations or to establish a case which will be inconsistent with the presumptions of innocence. Dons never change the accused to give an explanation or to establish case which will be inconsistent with the presumptions of innocence. The burden of proof in criminal cases are MAT VPP 1990 and 1963 MLJ 263. The general rule is that the prosecution bears the legal burden of proof, and Johansson VPP 1967 1 MLJ 210. The accused generally has only the evidential burden of raising the reasonable doubt in the mind of the trial court Woolmington v. DP, the burden of the proof on the prosecutions to prove guilt. No such burden laid on the accused to prove his innocence sufficient to raise doubt as to his guilt. And these are the criminal cases of these people. And evidential burden of leading evidence, lighter burden, an obligation that shifted between the practicise over the course of the hiring trail. A party may be submit evidence that the court will consider prima facie proof of some state of affairs. This creates an evidentiary burden upon the opposing parties to present evidence to refute the presumptions. And the other is criminal. The evidential burden of proof is often on the prosecutor to prove each essential element of the offense. Civil, the burden requires the plaintiff to the convinced judge that he is entitled to the relief sought. In conflict, prompted, and the burden of proof rests on who is arrested, not who denies. So section 102EA, burden of proof lies on a person who shall fail if no evidence were given. Evidential burden, establishment of prima facie cases. If the judge is convinced that there is some evidence not inherently incredible, if we were to accept it as accurate, we will establish each essential ingredients of the offense. And if these evidence are not rebutted, the accused is guilt convicted. Aziz bin Muhammad bin VPP, the burden of establishing a case must be constructed with the burden of introducing evidence, the evidential burden. The former is governed by S section 101 and the later by section 102EA. The burden of establishing a case rests throughout the trail on the party who assessed the affirmative. However, the burden of introducing evidence in a case here constantly as evidence is introduced by one side or the other. And the burden of proof rests throughout the trail on the party on whom the burden lies. Where a party on whom the burden of proof lies has discharged it, then the evidential burden shifts to the other party. What shift is a reasonable of adducing evidence to discharge the burden. If he does not adduce any evidence when the burden has shifted to him, he will fail. PLF was a clerk working off the tap. PLF claimed of erasures in his salary were deficient, contended that PLF come to him to study where he provided for a food, shelter, cloth, with no arguments as to salary. CT, the burden of proof never shifted to the PLF. The onus is on him to prove his case. If the position at the conclusion of the trail is exactly even, then the PLF's action must fail because he has not discharged the onus which is on him. And section 103EA, the burden of proof in effect lies on the person who wishes the court to believe in its existence unless it is provided by any law that the proof of that fact shall lie on any particular person. When a person on whom a burden lies fails to discharge it, there is no burden on the opposing party to disapprove it. Eastner Antipresis Ltd. PLF has not proved his case against theft. Thus, no burden shift to theft to prove the premises being used for immoral purposes. Defendant will not have to disprove something which has not been proved against him. And the other is 1998 1 MLG 697 was filed by Reps versus Prop of a app but not evidence adduced to prove ownership. App must show that he is the lawful owner of the property at the time of attachment. The burden of proof was thus on the app, but he had failed to discharge that the burden. In such circumstances, there is no onus on the rest to lead any evidence. So the scope of S103 burden of proof as to a particular fact lies on that person who wishes the court to believe in its existence. Karma Singh versus PP 1967 2 MLJ 25. A murder charge in a fighting over the use of a stand pipe in a hospital. Court's threats were uttered in the presence and hearing of 30 to 40 persons, but none was scarred by perceptions. Scope of Section 103 burden of proof prescribed by the law to lie on the particular persons, for example, to refute the perceptions or trafficking under Section 39B DDA 1952. Muhammad Rajeev PP 1991 3 MLG 169. The cause of the prosecution cases. The prosecution may of course rely on available stationary perceptions to prove one or more of the essential ingredients of the charge. When that occurs, the particular burden of a proof has posed to the journal. Burden shift to the defense to the report such as the perceptions on the balance of probabilities, which forms the defense point of view in heavier than the burden of casting a reasonable doubt, but it is certainly lighter than the burden of a prosecution to prove beyond a reasonable doubt. Scope Section 103 manner of discharging a burden placed on any person by law. This is about the PPV Muhammad Noor Janta 1972. The burden is on the lied one, and this can be discharged by evidence of witness for the prosecutions and defense. Duty of a party illegally in effect, and this is also for other. And the scope of Section 103 alibi illustrations. The burden of proof in a defendant's of alibi is on the person who rely on such a defendant's CI Section 11 and the Section 402A CPC. Yang Fangvir PP 1985 to CLL 22, the word establishing in his alibi. So this is all about the last slide is of Section 103, and this is all about the Section 104. Burden of providing fact, proof to make evidence, admissible factors, and wishes to prove are dying. Declaration made by BA must prove BS that CR 136. Other is the section of 105, and so this is all about the sections I discussed in this video, step by step, all sections about law. Section 103, Section 104, and now this is the part of section 105. I hope you liked my video. Thank you so much.